Welcome back to the Bob Harden Show. And now here's your host, Bob Harden.
Thanks so much for joining us here on the show. It's brought to you in part by Choice Social. It's a new, refreshing social networking platform, and you can find out more and download the app by visiting the website choicesocial.us. We have with us Kristian Stout. He's the Director of Innovation Policy at the International Center for Law and Economics. Kristian, thank you so much for joining us.
Hi, Bob. Nice to be with you this morning.
Thank you so much. Tell us about the International Center for Law and Economics.
Sure. International Center for Law and Economics is a policy research organization, sometimes called a think tank. What we do is we take the methodology of economic analysis and we apply it to law and public policy questions with the goal of having lawmakers have to do things like rigorous cost-benefit analysis and use empirical evidence when making public policy decisions.
Terrific mission indeed. I must say I did some research on your website. I saw that Henry Mann was one of your founders. And
yes.
And Henry, before he died, actually has been on my show several times.
Yeah, well, actually, Henry is our founder's father, Jeff. Jeff is the founder, but...
Okay. I didn't catch that nuance. But thank you, Kristian. So sure. You wrote this piece called "A Roadmap to Reform Section 512 of the Copyright Act." Maybe you could tell us about Section 512, what it is, and why this is important.
Sure. So Section 512 is part of the legal effort in the middle of the 1990s to try to figure out how to fit the American legal system onto the growing internet at the time. So it was written in the same era as Section 230, which tends to get more press these days, but it's just as important. The goal for Section 512, like on the Section 230 side, was to figure out how to adjust our legal environment in a way so that online platforms, online services could grow. And in this particular case, it was trying to find a way so that user-generated content could proliferate on the internet without copyright infringement stopping these services from operating.
So this is such an interesting question because there's just information proliferates, especially because of the internet. And I'm pretty certain that most people don't pay attention to copyright infringements when they're using information, either putting it on Facebook, whatever it might be. This is a big problem, isn't it?
It's a giant problem. So just to take a step back and understand the value of copyright, just domestically, the estimate is something around 5 to 10% of the U.S. economy is driven by copyright and related industries, which accounts for about $2.5 trillion. Mm-hmm. It's a massive driver, and it's also a major part of our comparative advantage internationally. So our international trade figures are even higher than that.
Yeah, and in addition to that, our copyright laws allow for innovation and allow for people to actually put their shoulder to the wheel and actually invent something, make something happen for the benefit of their own pocketbook, and ultimately perhaps sell something to somebody so that so they can develop it even more. But if you don't have those protections, people are going to stop putting their shoulder to the wheel to invent stuff.
Well, and it's a more complicated problem than that even. So, yeah, we want people to do this invention, but commercialization is also a huge part. So I can write a song in my home with a guitar. It might be the best song ever, but if there's no pathways in the economy to help me figure out how to reach audiences, how to actually make return on that, you don't incentivize all the firms throughout the economy to help me do that, and the copyright system facilitates that.
Right. So what types of changes, what would you recommend in order to facilitate protecting copyright law?
Great question. First, I don't want to overstate the problem and say that copyright law is fundamentally broken or anything like that. I think it actually works pretty well in a lot of cases. But over the last couple of decades, since the internet has grown up, we've seen in that edifice that could use fixing. So when 512 was written, some of the provisions in it were so how 512 works actually. Essentially, if a user on a platform posts something that potentially infringes copyright, under traditional copyright law, the hosting platform would have been liable for primary or secondary infringement, depending on how it happens. So they would actually have been liable for copyright infringement. 512 changed that and gave them what's called safe harbors, saying, well, we'll give you a chance. If the user uploads something and it infringes copyright, there'll be a notice period where you get to take it down, and that should work. The problem is the way the law was written was with dial-up speeds in mind. It was not written with high-speed internet in mind. So some of the way the provisions were interpreted by courts in the early years have aged in a way that don't reflect today. So getting to what I would recommend. One, courts have interpreted the knowledge standard, what it is a platform operator is assumed to know, when they should know copyright infringement is happening. They've interpreted it in ways that are too liberal in favor of allowing too much content to be posted online, what's called the red flag knowledge standards. I think there needs to be fixes there. When a platform has reason to believe someone's infringing, there should be more challenge to that safe harbor. It was also assumed in the 90s that these platforms and the large copyright holders and small copyright holders would work together to develop what are called standard technical measures. So standard ways, standard operating procedures, technology that could be used to identify infringing content and remove it. You see some providers have done this on their own. So like Google has, YouTube has a very effective one called Content ID, but there's no industry standards. There was a bill last year and this year that was intended to give the Library of Congress power to convene a proceeding to make sure this happens. I think that's important too. I have some others, but I can pause there if you want to ask questions about those.
Yeah, no, I guess my question is how much of a priority is this considering all the things that are going on in the world right now? Are you getting any legislators' attention with this?
Well, so there are. It's a great question. It is a problem insofar as we have so many other problems that occupy the attention of our legislators.
Yeah.
That said, there are a core group of legislators. Both it tends to be bipartisan too, which is good, and also might be why you don't see as much about it on the news because it doesn't pop as many headlines.
Right.
But there are a core group of legislators that are focused on this and are trying to work on this.
Very interesting. Kristian Stout, again, Director of Innovation Policy at the International Center for Law and Economics. Kristian, do you have a website?
Yeah, we're Law, L-A-W, Econ, E-C-O-N, Center, C-E-N-T-E-R.org.
Laweconcenter.org. Did I get that right?
Yep.
Okay.
LawEconCenter.org.
LawEconCenter.org. Kristian Stout, again, I just genuinely appreciate your commentary here on the show. So thank you so much for joining us.
Absolutely, Bob. Nice talking to you.
You as well. Thank you.